Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-excerpt attorney John Deaton commented on the rumors, saying there have been reports that the SEC may reach an agreement with Ripple before the trial begins. Notably, according to some XRP supporters, the purpose for this supposition is to allow the SEC to prevent its former personnel from testifying during the trial. The trial, which is related to the SEC's complaint against Ripple executives Garlinghouse and Larson, is set to begin in the second quarter of 2024. Interestingly, Mark Fagel, a former SEC officer and securities litigation specialist, has revealed new insight on a possible Ripple settlement. During a debate on X, an XRP fan questioned him whether the SEC would settle with Ripple before the trial began. Fagel responded by highlighting one important reason why the SEC may negotiate an arrangement with Ripple before the trial. Recent speculation has focused on a possible settlement between Ripple and the SEC. Among these rumors, some XRP supporters expect that Ripple will announce a settlement during its victory celebration on September 29 in New York. However, John Deaton, the creator of crypto law, US, has said that no settlement announcements would be made during the event. According to Deaton, a settlement might take place by the end of the year if the court overseeing the SEC's Coinbase case approves the crypto exchange's move to dismiss the case. While the SEC has made no mention of a settlement, Ripple has said that it is open to such an agreement. However, Ripple's sole need for a settlement was that the SEC classify XRP as a non-security. Remember that Judge Annalisa Torres ruled that XRP is not a security in and of itself. Following the judgment, Judge Torres delegated to her colleague magistrate Sarah Netburn judicial control of some aspects of the case, including the settlement. Notably, Magistrate Netburn directed the SEC and Ripple to choose 3 potential settlement conference dates. Because of the court's hectic schedule, the parties must submit the dates at least 6 to 8 weeks in advance. According to the ruling, the parties had not yet complied with the instruction at the time of publication. As a result, suspicion has grown that the parties, particularly the SEC, are not interested in reaching a settlement. As everyone waits for another large XR price increase, YouTuber and crypto analyst Zach Richter has revealed his thoughts on 3 scenarios that might trigger another massive XR price increase. Many individuals in the neighborhood are yearning for Zach's first point. The previous time Ripple defeated the SEC, the token's price skyrocketed. If the SEC's request for an interlocutory appeal is refused, a replay of what occurred on July 13 is possible. Members of the XRP community are anxiously awaiting the judgment, and some experts anticipate the SEC's appeal will fail. The second point will likewise be a significant turning point in Ripple's voyage. Ripple's on-demand liquidity. OATL technology enables real-time cross-border money transfer and liquidity management. It is efficient and does not need any upfront investment in the target market. OATL employs XRP as a bridge currency, and the acceptance of XR by a large U.S. bank or financial institution will result in increased XRP adoption. Ripple Steve to David Schwartz has said that, owing to the partial victory over the SEC, XRP is second only to Bitcoin on the list of cryptocurrencies having regulatory certainty in the United States. This might provide these institutions the confidence they need to incorporate XRP into their operations through OATL, hence driving up the price of XRP. If Zach's last event occurs, it might be a significant one. David Schwartz has already confirmed several announcements for the impending celebration party, including a possible settlement with the SEC. If that occurs, the price of XRP might skyrocket. A positive settlement for Ripple and XRP will also be a significant turning point for the rest of the crypto business in the United States, potentially propelling the whole market higher. This, however, is not shared by the whole community. According to one user, the only relevant driver for XR price growth is new use cases. Zach's list he characterizes as pump and dump catalyst. Ripple, the well-known payments business that created the cryptocurrency XRP, takes an unexpected move. It is collaborating with Jared Isaacman, well known as Elon Musk's SpaceX colleague. In 2020, Isaacman, the millionaire creator of Shift4 Payments, made news, specifically when he launched into Earth orbit on SpaceX's Crew Dragon spaceship. Ripple has announced its participation in a humanitarian venture, with Isaacman in a recent release. The collaborative effort includes a contribution project combining XRP and cryptocurrency for the Maui Emergency Response Fund. XRP has been incorporated as one of the cryptocurrency contribution alternatives offered via the Giving Block, a crypto donation solution provider, as part of this initiative. A statement from an article in the post above emphasizes the collaboration. Ripple will join Shift4 CEO Jared Isaacman, and the next $50,000 used in cryptocurrency donations to the Maui Relief Fund will be matched 200 ETH. Donation matching is used in this partnership, in which one party matches the donations provided by another. Ripple has agreed to match Isaacman's contributions, essentially doubling the Bitcoin donations received up to a total of $50,000. While this cooperation does not prove a strong link between Jared Isaacman and Ripple, it does provide opportunity for conjecture regarding possible future collaborations. Elon Musk, well known for his prominent tweets regarding cryptocurrencies, particularly Dogecoin, has had a big influence on the crypto market via his social media activities. Notably, during the crypto market's bull run in 2021, SpaceX and Tesla earlier added Dogecoin as a payment option on their websites for the purchase of corporate items. Ripple Labs has stated its dissatisfaction with the SEC's request for an interlocutory appeal in court, joined by its senior executives, Brad Garlinghouse and Chris Larson. Ripple claims that the present court verdict does not support an appeal and points to the SEC's selective regulation of the cryptocurrency sector. This selective approach raises questions about how the SEC implements the Howey test, which determines whether a digital asset is a security or not. This discovery has far-reaching implications for the current court dispute. The SEC identifies no prejudice that it would suffer in being required to try the allegations that it brought and has maintained against Mr. Garlinghouse and Mr. Larson for nearly 3 years, according to a portion of the petition released by attorney James A. Key. Fallon. And the SEC refuses to recognize much alone remedy, the significant damage that additional delay will inflict the individual defendants. The SEC's half-hearted stay motion lacks legal, factual, and equitable basis. According to attorney Fred Rispoli, Judge Torres is unlikely to grant the SEC's motion. He claims that not only does the legal analysis back Ripple, but there is also serious worry about possible injury to people such as Brad Garlinghouse and Chris Larson, rather than merely the firm. He compares this to the entitlement to a prompt trial in criminal matters. He goes on to say that the only way Judge Torres might certify the appeal is if she sees the matter as very political and wants not to get too engaged. In such a case, she may choose to refer it to the Second Circuit, enabling them to determine whether or not to grant the appeal, thereby putting the decision in their hands. According to Rispoli, Judge Torres does not support this technique. The SEC is requesting an interlocutory appeal, claiming that the Ripple case poses fundamental legal issues with far-reaching repercussions for the entire digital asset market. Ripple has countered with many arguments. In the midst of the legal saga between Ripple and the SEC, John Deaton, a legal champion for XRP investors, provides a ray of light. He reveals the legal complexities that might lead to a settlement between Ripple and the SEC. Deaton's insight comes at a critical juncture: the legal battle between Coinbase and the SEC. If the court rejects Coinbase's request, the regulatory environment for token sales, including XRP, might change substantially. A rejection like this would erode the SEC's power to appeal, pushing the agency toward a settlement with Ripple. Deaton believes that even if an appeal were viable, the agency's power would wane, making a settlement more appealing. Ripple has also not been idle. In a recent filing, it argued that the SEC had strayed from legal principles, particularly with regard to the Howey test for token sales. This development follows a positive July verdict for Ripple, which prompted numerous exchanges to consider relisting XRP. A settlement between Ripple and the SEC might not only pave the way for XRP, but it could also have an impact on the larger cryptocurrency industry, setting new precedents. If the move to dismiss is granted, the future for Ripple and Coinbase appears more bright. Such a decision would establish new precedents in the crypto industry, providing much-needed clarity and encouraging innovation.